Your non-compete is worthless. Those 4 words saved my client's career. After fighting hundreds of non-compete battles, I'm exposing the secret weapons that can shatter these career-killing contracts. 2025's game-changing update changes everything. Today we're diving into a critical topic for business owners, employers, and employees alike. Are non-compete agreements enforceable in Florida under the 2025 legal landscape? Whether you're a business trying to protect your legitimate business interest or an employee wondering if you're truly bound by that contract, understanding the law is key. Let's start with the foundation. A non-compete agreement is essentially a contract that prevents an employee from working for a competitor or starting a competing business within a certain geographic scope and for a specific period of time. The goal is to protect the employer's investment in trade secrets, customer relationships, and other proprietary information. However, these agreements can't be overly restrictive or they won't hold up in court. Now let's talk enforceability. Florida law generally upholds non-compete agreements, but only if they meet specific requirements. One of the most important factors is reasonableness. Courts will not enforce a restriction that is too broad or unfairly limits an individual's ability to earn a living. This is where reasonable restrictions come into play. If an agreement imposes an excessive time limitation or an unreasonably large geographic scope, a judge might refuse to enforce it altogether. So what is considered reasonable? Under Florida law, time limitations should be tailored to the business's needs. Typically, agreements lasting 6 months to 2 years are more likely to be upheld. Anything longer may face scrutiny unless there's a compelling justification, such as protecting highly sensitive proprietary information. Geographic scope is another crucial factor. Courts will examine whether the restricted area is appropriate given the employer's market. If a local business tries to impose a nationwide restriction on an employee who only worked in a specific county, that would be deemed excessive. A reasonable geographic scope depends on the employer's actual business footprint. The agreement must also serve a legitimate business interest. Florida law identifies several legitimate business interests that justify non-compete, including protecting trade secrets, confidential business information, substantial relationships with specific customers, and specialized training. Without a clear business interest, the agreement won't hold up in court. Now let's talk enforcement. If an employer believes a former employee has violated a non-compete agreement, they can seek an injunction, which is a court order stopping the employee from engaging in competing activities. The employer must demonstrate that the agreement meets legal standards and that the violation is causing actual harm. However, if the agreement is too restrictive, courts may refuse enforcement or even modify the terms through a process known as reformation. Recent court decisions in Florida have emphasized that courts won't enforce non-compete agreements simply to punish an employee or stifle competition. Judges are looking closely at the agreement's fairness, the impact on the employee, and whether the employer has a valid business justification. If an agreement is challenged, courts may reduce the time limitations, shrink the geographic scope, or eliminate overly broad restrictions altogether. Employees facing non-compete disputes often have legal defenses available. One common defense is that the employer failed to demonstrate a legitimate business interest. If an employee wasn't given access to trade secrets or specialized training, the employer may struggle to justify the restriction. Another defense is that the agreement is overly broad, making it unreasonable and unenforceable. Some employees also argue that the employer breached the employment contract first, making the non-compete invalid. For business owners, the key takeaway is that a non-compete agreement must be carefully crafted to align with Florida's legal standards. Simply copying and pasting a generic template could lead to a contract that's ultimately unenforceable. Employers should ensure that restrictions are narrowly tailored, time limitations are reasonable, and the geographic scope reflects the actual business needs. Working with an attorney to draft a legally sound agreement can prevent costly legal battles down the road. For employees, it's important to understand your rights before signing a non-compete. If you're presented with one, consider whether the restrictions are reasonable and whether you're truly receiving something in return, such as a promotion or specialized training. If you have questions, consulting with a legal professional can help you determine whether the agreement is likely to hold up if challenged. Florida courts will continue to refine their approach to non-compete agreements in 2025 and beyond. Employers and employees alike must stay informed about new court precedent and statutory updates. Whether you're drafting, signing, or challenging a non-compete agreement, understanding the legal landscape can make all the difference. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.